because as is the case with the other two issues, neither the prosecution nor the investigating agency nor Justice Nazlan declare so that we should know this. And we discovered that Justice Nazlan was highly involved not only in the processing of the loan, but more importantly when the loan became sour in 2014. He was again involved in the recovery of the loan, and he made various suggestions and comments, and he would have passed judgment about 1MDB. Now, 1MDB is wholly owned by MOF Incorporated. SRC was wholly owned by 1MDB. Then later on, SRC became wholly owned by MOF directly. So they are associated companies, common shareholder. It is impossible for Justice Nazlan or the investigating agency or the prosecution not to know this. So this conflict of interest is very critical, because if this is true, Justice Nazlan is a potential witness in the 1MDB case that is ongoing. And this document has been tendered in the 1MDB case recently through Azmi Tahir. Okay? So he's a witness, he's involved in the loan processing, he's involved in the 140 million to PPD, and he is certainly involved in the critical element of of SRC. Whether SRC was the brainchild of Datuk Sri Najib, or it was the brainchild of 1MDB, but processed by Maybank itself. All these point to Justice Nazlan. So there is a massive conflict of interest. Now you remember, before the start of the trial before Justice Nazlan, we had Justice Sophian. Justice Sophian was transferred within 24 hours. Yeah? And the rumor was apparently his brother was a division chairman and exco of Pahang, which is representing Barisan Nasional or UMNO, whatever the case may be. But you and I know, in law, what your brother does has got nothing to do with you. Okay? Nothing to do with you. Yet he was transferred because we think he was transferred because there were rumors that this is a conflict of interest. So you imagine that and compare that to what I've just told you of the conflict that we have just produced and filed this evening against Justice Nazlan, against the prosecution, and as well as against what conduct the MACC has undertaken in not disclosing this to us. Alright? So we think that this application is important. It ought to be heard first before even the appeal, whether very much earlier or almost near to the appeal, it doesn't matter, but it has got to be heard as a matter of urgency and as a matter of priority. Now the reason why this is important is because if the federal court agrees with us, the trial becomes a nullity, because it is a breach of the rule against bias. Remember, a judge cannot be biased. That means if there was a real danger of bias, because the judge is equipped with knowledge about SRC, about 1MDB, and many other factors that I've just mentioned to you, he should not be hearing the case. He should have just declared, I'm not qualified. You remember recently there was a judge, I think the son of the former Chief Justice Arifin Zakaria, and the judge here was Arif Imran. He was given a task to hear a case involving 1MDB. And he called all of us in and he said, I can't hear this case because my former firm has acted in one or two matters, but not him. His former firm has acted for 1MDB and related companies. And therefore he said, I recuse myself. That is what a judge with integrity must do. Yeah, you must dispel any suspicion, and you must ensure that not only justice is done, but justice must be seen to be done, which is very important. Okay?
Actually, earlier when you said that Justice Nazlan is involved with the loans and all that, do you mean in his position as in what position? Can you clarify?
In his position as Counsel General and Company Secretary. Company Secretary is not a Company Secretary. When you are a lawyer, you are Counsel General. Company Secretary is you undertake all legal work pertaining to the companies. Here he was Counsel General for the whole group of Malayan Banking and also the head of corporate legal legal services. So in the terms of office, the citation was he was to undertake the review of all legal documentation, legal matters pertaining to everything in the group. So he's deemed to know, and we think he's also got actual knowledge about the SRC creation, because it is Maybank investment, and then Bina Fikir is another of their subsidiary. And then the 140 million taken by PPD from Maybank, and that is the money that went, 42 million went into Datuk Seri account. Never the 4 billion. So everybody pretended, the prosecution pretended, Justice Nazlan assumed he must have some relationship with the 4 billion. Remember I said that this is not a pathology of corruption because the 4 billion was disbursed almost 3 years earlier to the money of 42 million going into the Datuk Seri Najib account. It just doesn't make sense. When you have 4 billion, why you delay 3 years? You should just put in the money or even ahead of time. Okay? Is that clear?
Sir,
yes.
Going down the road for the purpose of justice to be served for the issue, with new evidence being filed, do you see it appropriate for the federal court to push back the decision date in August?
To push back? You mean the hearing date?
Yeah.
Well, a few things can happen. What we have asked
My
is...
question was, for justice to be served, do you think it should be pushed back?
Push back meaning postpone that?
Postpone, yeah.
Okay. We are saying the decision ought to be that forget about the merits of the appeal. He never had a chance in the trial because the trial was unfair. Because the judge who presided over the case had massive conflict of interest in at least 3-4 areas. Massive conflict of interest. He was involved in Malayan banking over matters relating to SRC and 1MDB. Remember, there is a very important case called Pinochet No. 2. It is General Pinochet who was being requested to be extradited to Spain because of his crimes against humanity. He was, the House of Lords said, extradite him. Decision has been made. Then they discovered one of the 5 judges, Lord Hoffman, his wife was involved in a welfare work in a branch to an organization that is actively involved in the request for extradition. Nothing more. She was doing welfare work, nothing to do with the application. But the House of Lords decided that gives the impression that there is a breach of the rule against bias. And they declared that proceeding in the House of Lords was null and void. They reconstituted a fresh hearing with new judges to hear the case. So here what can happen is, either they can acquit and say this has gone very wrong, or they can say let's do a retrial before a different judge. So the appeal become unnecessary. That's how important is this application.
So what about the application to bring in a QC? What's the latest on that? The date for that?
Okay, there is a date on the 16 June for a case management before a judge in the High Court. Yes. Yes. Anything else? Well, we are doing it simultaneously. Okay? Because if the QC is admitted early, perhaps even in time for this, you may find the QC arguing this as well. It all depends. Yeah? Anything else? Well, I've been cleared 2 days ago. 2 days ago, my Sejatera says I'm back to blue. No more red. Okay? Yeah, negative. Because by the time I realized I had COVID, 5 days has passed without me knowing I had COVID. So, the period is normally 7 days for you to be over. So I waited for another 4 days. I'm clear. Okay? All right. Thank you very much.